you were talking about how returning the property or restoring the property from the state. Here's an issue. It's from the other parents, and the other parent isn't exactly being 100% in. So I was wondering, seeing as how that you did make a comment earlier on about how if you answer their questions and you answer to the name, they pretty much have jurisdiction over you. If they answer to the name and you still require the restoration of your property, and the other side or the other party is under the jurisdiction of the court, does the court have the authority to direct the other party to return to restore the property?
Yeah, like I said, it depends. Like I said, you have to create your own court then, because the other side has got the jurisdiction. See, like say I create a case and you create a case. I take my case and I place it. If I say I want to place before like God and country, God, just to be the witness, and country means my jury, my peers. That's all God and country means. Now, if I want to take my case and place it before a guy in a black robe, I surrendered my case to the guy in a black robe, and I no longer have control of my case because I gave it to somebody else. Same thing with the jury. Once I surrender my case, I say, look, I said to the court clerks, I wish for my case to remain sealed until it comes forth into the open court in front of a jury, until the trial by jury. And then upon that time, I'll open my case and I'll, try on my suit before the jury. Until then, this case is to remain sealed. So that way nobody can interpret it or say, tamper with my case. Nobody's going to trespass on my case. Nobody's going to take out my, try on a suit. It's a golden suit with silver thread. I don't want somebody to replace my silver thread with tin. So it's my suit. Leave it alone. Don't give me no opinions. Don't do anything. Wait for the trial by jury and let me try on my suit before the jury. So if the other side, like I said, surrendered his case to the judge in the black robe, he placed the case or complaint before the court, and he surrendered it or she surrendered it already, now that judge is technically the other person, is saying, okay, I've only heard one side of this case, the other side refused to answer into this case, so obviously this case is going to, I'm going to find it has merit, and I'm going to give a judgment for this case. So you have to, if you don't want to be part of the other person's case, you better start your own damn case. And when you start your own damn case, then if you trust a guy in a black robe, you better require a trial by jury be, convened.
Yeah. Looks like Pat just jumped on there, Carl.
Okay, great, man. Yeah, but this was a Sindra who was just talking to me?
Yeah.
Okay, can you send me that stuff that you said you actually worked, so I could send it to that other parent in Alabama and try to make them feel better?
Yeah, but I still have a follow-up question I wanted to quickly ask there. See, Ontario courts, they don't really take in just blank notices if you're trying to claim things from the other party. They require you to fill out the family court forms, et cetera, so on and whatever, and that's pretty much the only way that you'll be able to get anything done. They don't accept any notices because they won't even take it. If you send registered mail, they'll just return the sender or anything. They will not keep the notices if it has to do with another parent. That's my problem.
Yeah, well, like I said, what you could do is you send me this in like a long form of a question, because it kind of sounds there's something missing in your questioning. So you're going to have to form it in a letter and send it to my email. Because, like I said, you want to figure out how to procedurally, submit a notice to the other side. Like I said, if they won't take it that way, then you might have to go through legal, the legal announcements in the newspaper, or just put the notice there. So like I said, just give me, like I said, that's exactly what they do to you. Social services, like up there, they will say if anybody wants to come forth and make a claim for a child that we have in our custody, he's 4 years old, blue eyes, brown hair, he goes by the name that they have to put a legal notice in the newspaper that we're going to, adopt this child out or whatever I have here. They actually have to have that they're going to terminate the parents' rights. They actually have to put that in the local newspapers. I don't know if you've ever seen that in the legal section of the newspapers.
Yes.
Yeah,
I did.
So, like I said, if you want to, put it in a long form of a question. So, so I could see, because you sound like you know what you're doing. So I don't want to repeat. You already know what the hell you're doing. So I'm just wasting my time telling you what you already know.
Yeah,
So
but
just tell me what you've done and haven't done. You know what I'm saying?
The thing is the court is exactly operating. So, like, in Canada, we have something called the security of the person. It's actually just a piece of paper. The person is just a security. So you just lien it, and then you throw it in trust. And then technically it's in custody of the trust, right? Well, court isn't exactly following that anymore.
It depends. It depends, man. It depends.
Okay.
You know, like I said, it depends. Who's got the authority to do such an act? You know what I'm saying? It depends. It's not as simple as you're making it sound like.
Of course, I'm simplifying it because I'm just trying to rush it through. But what's the email that you go by?
That's courtofrecord@gmail.com. So, yeah, like I said, you better be careful because my buddy Gus just came out of jail for a year and a half doing what you're saying. So you better be real careful what you do, dude. Yeah, you know, he got a 2-year sentence and was letting a year and a half go. So you better, like I said, you better tell me, you know, more of a form like a letter. Tell me what you have and haven't done.
Yeah, in Ontario, there's a beautiful thing. It's called the Change of Name Act, Section 2, subsection 1B2. If you're born outside of Ontario, or if you're born in Ontario, it's Section 2, subsection 1A. It specifically states, for the purpose of Ontario law, everyone has an entitlement to be recognized by the name. You just simply waive the entitlement, and if they don't allow you to do so, then you just question the court, by what authority do you have to compel me to accept an entitlement?
Right.
That got all of my charges thrown out.
I tell people all the time about the titles. I said, you don't have to accept the title.
Exactly. And it says right in your own
look, I got too much on my plate. You could just be as nice as saying I got too much on my plate. I'm entitled as a dad. I'm entitled as an uncle. I'm entitled as a cousin. I'm entitled as a worker, an employee. I just got titles up the behind, and I can't accept any more titles. I can't handle any more duties, responsibilities, obligations, and you can't bind me to it. And I wish to be let alone. And if they say, but this is a great title, you're defending in a wonderful case. It's like, yeah, I'm sure it's a wonderful case. You know, I'm sure you spent tens of thousands of dollars building this case. That's great. But you know what? I don't want to defend your case. You defend your own castle. You know, it's your case. You defend it.